and welcome to the second episode within the third series of online education sessions from Salts Healthcare. If you've been unable to watch the first episode, where we explore the legal obligations with regards to accessing and storing patient data, it's not too late. This episode can be accessed via the Salts Healthcare website at www.salts.co.uk/discover series. Within this second episode, we will hear from Mark Cawley, who joined Irwin Mitchell in 2013 and is now working as a senior associate in the Birmingham Medical Negligence team. Mark specialises in medical law cases in areas such as accident and emergency, cancer, misdiagnosis, and surgery. Mark will explore the concept of consent, the importance of obtaining consent, and how this has altered for many of us who have been working predominantly via a virtual platform to engage with patients.
Hello everyone, my name is Mark Cawley. I'm an Associate Solicitor at Irwin Mitchell. I'm delighted to talk to you today about the law of consent and the digital age. Just to go over a few of the topic areas which we'll be covering today. We're going to go back to basics in terms of what is consent and why it's required. We're going to look at the differences between common law consent and statute. We're going to talk about how implied consent compares to explicit consent. We're going to talk about some video conferencing tools and how consent relates to those. We're also going to explore areas of difficulty such as sensitive patient data or intimate examinations. And we're also going to touch upon the importance of valid consent in a legal context. And I was hoping we were going to finish as well by looking at a case study from my work, if that's okay with everyone too. Okay, so first of all, what is consent? So consent to treatment means a person must give permission before they receive any type of medical treatment, test, or examination. So importantly, consent must be voluntary and informed, and the person consenting must have the capacity to make the decision. Adults who lack capacity under the Mental Capacity Act, that would be covered under a separate talk from today. And there are lots more legal considerations for an adult who lacks capacity. So today I'm really going to be focusing on patients who do have capacity. Okay, so consent must be voluntary. So when I say voluntary, the decision for anything must be made by the patient, and they can't be unduly influenced by family members or yourselves as clinicians. They need to make the decisions independently. Consent must be informed, so they must be given information about what treatment involves, including the benefits and risks, whether there are alternative treatments, and importantly, what will happen if treatment doesn't go ahead. And if after an explanation and a consultation, a discussion around the risks and benefits of a particular treatment has taken place and an adult has declined for that treatment to take place, then that decision must be respected. So why is it important in a professional context? Well, I've taken this directly from the Code for Professional Standards of Practice for nurses, midwives and nursing associates. So 4.2 within the code, one must make sure that you get properly informed consent and document it before carrying out any action. It really underpins all medical treatment, the doctrine of consent. So what does consent mean in terms of the common law? Well, common law is case law that's developed through the courts that make points on decision. It's different from statutes, which derive from Parliament. In common law, there's a duty of confidentiality, which means when a patient shares information in confidence, it must not be disclosed without some form of legal authority or justification. In practice, this usually means that information cannot be disclosed without that person's consent. For individual care, which I would imagine is largely what most of you will cover, that consent can be implied consent. I've used an example there of a multidisciplinary team meeting. It would be implied that the benefits of sharing medical information of a patient amongst colleagues would be in their best interests. For anything that goes beyond individual care, explicit consent is generally required, and we will touch on that further. So I'm not going to spend very long on this area, but GDPR is the statutory regulations for governing consent and data protection issues. There's a very high threshold for consent, and there's no such thing as implied consent under GDPR. What that means is when consent is taken, it should be given freely, it needs to be informed, unambiguous, and clearly needs to show the patient's agreement to the processing of personal data. And this is often things such as a written statement, including electronic means. You may see forms of authority where the patient's actually required to sign to confirm their consent. Now, implied consent is where, for example, if a patient where information is shared confidentially and it's accessed confidentially, and in a clinical context, that consent can be implied without having the individuals explicitly say so. This is because it is reasonable for a patient to expect that relevant confidential information about their care may be shared amongst other clinicians on a need-to-know basis. So I touched on that earlier example of a multidisciplinary team meeting. Clearly, it's in the best interest for that kind of confidential patient information to be shared with colleagues. That would be implied consent because it's in the patient's best interest to do so. However, consent can be inferred from the patient's conduct. So just by way of example, a very, very old case in 1891, an American who held out their arm during a smallpox inoculation was held to have consented. And equally, silence does not also necessarily constitute consent. The will of a patient must accompany consent, which is really important. Explicit consent is more, I suppose, commonly seen in things like operative consent forms, where the relevant risks and benefits of a particular procedure are listed on a form, and the patient signs that form to provide their consent to treatment. And another example in terms of explicit consent and why it's important is, for example, if a patient's taking part in a research project or clinical trials, or obviously having very, very clear written consent in those circumstances is really important. Consent and obtaining consent has changed dramatically in the past 2 years. Obviously, the impact of COVID-19 and less and less patients attending hospital appointments means that more and more consultations are taking place over video conferencing tools. And there are positives and negatives to using video conferencing tools for patient consultations. One of the first considerations when using video conferencing tools is actually whether a patient has actually consented to using that video conferencing tool for the consultation. And helpfully, if a patient has accepted an invite to have that consultation on a video conferencing platform, then it is implied that they, by accepting the invite, they have provided their consent for entering the consultation. Another important consideration is perhaps where patients don't particularly have the digital skills required to use those tools independently. And often you may see carers or family members help them in terms of entering the consultation and throughout. And again, it's really important that consent is obtained actually for that person to be present during the consultation. I think from a confidentiality point of view, it should be treated in the same way as any other consultation would be, including face-to-face consultations. For example, you may be in a hospital room or clinical environment when you're conducting the video conferencing consultation when the patient's at home. It's really important to make sure you don't inadvertently breach patient confidentiality. A common example is having a whiteboard behind you with patient information on, for example. So it's really important that that not only the patient, but also that you're in a private area too, so that passers-by can't overhear, and you're in a safe and secure environment for the consultation to go ahead. And if for example, you're contacting a patient and they're in the middle of a supermarket, or they've popped out to the shops, you really have to ask yourself, is it appropriate for the consultation to go ahead? And it might be more appropriate to reschedule in those circumstances, because the discussion that takes place is very sensitive, and it's important that just because it's on video conferencing, you don't lose that integrity and that security of having a confidential discussion. If you are holding a group session, I know often patients, when coming together in support groups, for example, it may be appropriate to have a group session on a video conferencing tool. That is okay, but again, from protecting confidentiality, it's really important that an individual has provided consent for them to appear on video with other patients, and for example, if it's being recorded, and that must be done in advance. Some more tips for using consultations in terms of video conferencing. It's really important from the outset. It sounds simple, but making sure that it is actually the patient you're speaking to. Often patients may share email addresses with a family member, a husband, a wife, and it's really important that when the consultation first begins, that you verify their identity and make sure that you have the correct notes too. And if the patient is at home, it's not uncommon, obviously for someone else to be in the house at the same time. And if someone is in the room, I think it's important that you ask for them to identify themselves and actually make sure that the patient is comfortable with someone else being in the room too. Some patients understandably want family members there for support, but equally from a professional point of view, I think it's your duty to make sure actually that they're happy with individuals being in the room. And in a clinical context in a hospital, it's much easier to read a patient's body language and to make sure that they're comfortable, whereas on video I think that can be harder. So I think it's important from the outset that you address those concerns. Equally, if it's going to be recorded, again, that has to be that consent has to be obtained for the recording to take place. And the same complications that happen for any kind of video conference can happen for patient consultation. So again, it's really important that you've ended the call, that the microphone is muted, that you don't inadvertently share other patient data that could breach confidentiality. And I think from a practical point of view, it can be really hard, I'm sure, for you to feel satisfied that a patient has properly understood your consultation and any advice that you've given. And there can be a tendency for anyone on video to just sort of nod along. And I think it's really important that you ask regular questions throughout the consultation, and at the end, perhaps maybe ask the patient to repeat back to you a summary of the consultation, or perhaps specific questions about their treatment or what's happening with them at that time, just to satisfy you that they have understood the basis of the consultation. And equally, in terms of next steps or safety netting, if the patient hasn't really quite understood something, how are they going to get back in touch to ask further questions or seek clarification and make sure that everyone's working on the same page? So I think it's important to think about those things before ending the consultation, just to make sure that the patient's properly understood. And I think another area which is even more complicated by the use of video conferencing is intimate examinations of patients. So for example, a patient thinks they may have an infected site, and they would like you as their clinician to have a look at the potentially infected site and to give them advice, support or recommendations for treatment. And there are additional complications when looking at that. that need to be mitigated, and to make sure that the patient is safeguarded, and also yourselves as well as professionals, to make sure that those examinations are carried out appropriately. So helpfully, the General Medical Council and the Nursing and Midwifery Council have provided guidance on this. And it's really important when talking about consent that informed consent has been taken to receive or store a patient's image as necessary. For example, they want to send you a picture of a potential infection, and they want you to look at that and read it. It's really important. Of course, they want you to see it. It's important that they've understood what's going to happen once you've received it, how it's going to be stored. And from a professional point of view, you need to be satisfied that if an image is going into the patient's clinical record, that it's justifiable and it's transparent for you to do so. And you should only really store the image if you think this is what you would do in a face-to-face consultation. And when I talk about how data storage, I think it's really important as well. Again, looking back at your employer's own rules, codes on this, is it's not appropriate to use personal devices, things like personal WhatsApp accounts or anything which would that your professional role doesn't necessarily have control of. So if you are asking for a patient to share an image, that they do so within the platforms that have been provided by your employer, and that they're also stored securely in accordance with your employer's data protection rules and privacy statements. Often it can be quicker to use something like WhatsApp, but I would urge caution and make sure that images are shared appropriately. Equally, if a patient actually decides that they don't want that image to be retained, then it's important that you think as a clinician, how am I going to be able to provide advice without necessarily seeing that image? And helpfully, we are in a different place to lockdown during the COVID-19 pandemic, but we have to look at actually whether a face-to-face consultation is going to be more appropriate in order to properly assess that issue that the patient may have. I think when having those discussions around an intimate examination or the sharing of images, it's important to understand why it would be helpful from your point as a professional of seeing that kind of image. And equally, if the image is going to be shared with other clinicians, how they're going to see that image, how it's going to be shared, how it's going to be used in terms of determining perhaps the patient's clinical pathway, all that needs to be explained to the patient, and they need to understand that before sharing any image. Again, if they don't feel comfortable, if they feel under pressure to do something, then it's important that doesn't take place, and actually alternative options for an examination are provided. Crucially, the refusal to share an image doesn't prevent them from accessing that care and treatment that ultimately that they need. So moving on in terms of a legal context, why consent is so important, and why obtaining valid consent is so important. Well, I touched on at the beginning in terms of how a consent can be expressed or implied. There's no actual strict requirement for consent to be provided in writing in some circumstances, although now it's a very common feature and often best practice in terms of consent forms, and asking a patient to consent in writing is often the best way forward in terms of evidencing good consent. But really, I think the important considerations and often the most impactful area in terms of obtaining a patient's understanding of what's happening is the discussion that takes place around the treatment, and actually providing the patient with enough information that they can make that informed decision. And it's not enough to rely on what your usual practice would be in terms of discussing risks or benefits of a certain procedure. You have to take the patient as an individual and really make sure that they've understood your advice, the risks, if there are any, and ultimately next steps as well. There's a very famous case on patient consent called Montgomery. The law prior to Montgomery was often known as the Boland test. And what this meant was that the standard of care in claims arising from failed treatment, it meant that a clinician was not guilty of negligence if they had acted in accordance with a practice endorsed by a responsible body of practitioners in their field. And in Blythe, though, the House of Lords added the proviso that the responsible body of opinion must also withstand logical analysis. So what that meant was essentially, would a responsible body of clinicians explain the risks and benefits of a procedure in the same way? And if so, then the test would have been satisfied and there would be no negligence in those circumstances. Montgomery was a case involving a lady who had a vaginal delivery, and she had diabetes and suffered complications during that delivery. And ultimately, it was held that actually, had their risks and benefits been explained of a cesarean section, that ultimately she would have opted to have one of those instead, and the injury to her child would have been avoided. And that completely changed the law on consent, because essentially now a clinician is under a duty to take reasonable care to ensure a patient is aware of any material risks which are involved in the recommended treatment, and of any reasonable alternative and variant treatments. And the key words there are material risks. The test of materiality is whether in that particular case with that particular patient, they would likely attach significance to that risk. And that's really important in terms of obtaining consent moving forwards in medical cases, because now we're much more case specific, it's fact sensitive, and would a patient attach significance to a risk? And you really have to make sure that that discussion of all the risks and benefits is thorough, and make sure that the patient has all the information they need in terms of reaching that final decision. I think it's important from my example of a case study here in terms of a patient who had a stoma. This case study example in terms of consent was in the context of an adenocarcinoma of the rectum. So this particular patient was advised to undergo a laparoscopic Hartmann procedure, and the consent form for the procedure included, as you can see on my presentation there, a laparoscopic open Hartmann's procedure for the removal of the tumour. Importantly, in the patient's medical records, there was no record of where the stoma site was located, but the patient could remember, and his wife could also recall, that the stoma nurse had marked the stoma site preoperatively. What actually happened it was that the operation performed was not a Hartmann procedure, which removes the tumour and obviously involves the fitting of stoma, and that could be reversed later. What actually happened was that an abdominoperineal excision of the rectum was performed, and this also meant that it wasn't just a rectal tumour, but all of the normal bowel below it, as well as the anal canal, and this meant that the patient was ultimately committed to a permanent colostomy. And what was important here is that the stoma hadn't been sited in the position that had been marked preoperatively by the stoma nurse. Instead, it had been sited 2 inches above. And because of that, it wasn't in an ideal position and caused a whole host of issues post-operatively. What was important here was that actually the anterior resection would have achieved the intended benefits of the surgery in removing the cancer, and only carried a 10% risk of a temporary covering stoma that might be needed. And ultimately, had it been carried out, it could have been done laparoscopically instead of an open procedure. And the issue here in terms of consent is that the patient had been consented for a Hartmann's procedure which wasn't performed. That's ultimately assault in terms of a legal context. And what I think the important lessons are here in terms of obtaining consent is that the patient had absolutely no idea that there were alternative methods of performing a certain procedure, including laparoscopic versus open. And they had no idea if it being more invasive than might have been intended. Ultimately, the importance of that preoperative discussion, not just by the surgeon, but by all those, in terms of having interactions with the patient, is to make sure that they had properly understood the nature of the procedure and they properly provided their consent for that treatment to take place. again, recording that in the medical records, the quality of note recording is so important. There are a whole host of issues here in terms of where the stoma site had or hadn't been placed, and but making sure that's accurately recorded in the records, the patient's aware of those risks before the procedure taking place and provides their consent before moving forwards is really important. And again, from a professional point of view, not thinking that will be dealt with by a colleague, perhaps at a later stage, and actually taking responsibility and thinking, I'm going to have this discussion with the patient and make sure they understand everything. And I know that there are certain circumstances where perhaps a pre-operation consultation might take place by video now as opposed to in person. And that just highlights the importance of these discussions even more. And really, when concluding that discussion, we need to be thinking, has the patient properly understood everything? And if not, what are we going to do about it? Are we going to arrange a follow-up consultation? Are we going to see them in person? And really making sure that they've understood everything before proceeding with any type of treatment. Now, in conclusion, really, I just wanted to summarise by saying that I know a lot of specialist nurses have since COVID-19 been predominantly working via virtual video conferencing tools to engage with patients. And one might ask, well, how does that impact on my responsibilities as a professional? Well, I actually think, if anything, those responsibilities have increased. I think discussions around treatment, giving advice to a patient, I think they're probably easier in person, and it's more of a challenge when holding those discussions over video. So I think those responsibilities have increased. And I think in terms of not only just using the software, but also how patient data, how images, how recordings are stored as well. And I think it's important that you ask yourself, what is the most safest and robust method of storing this data? And am I acting in accordance with my employer's data protection rules? And I would always ask the question if you're not sure on what's appropriate to do in terms of accessing or sharing patient data or images before that takes place. And I think in terms of the picture we now find ourselves in terms of remote consultations, it's all had an impact on the way in which we practice, both medically, legally, and from a patient perspective, how they access advice and support from a clinician. But it's really important that you actually step back and think, have I addressed the legal obligations regarding informed consent? Have I stored patient data or images appropriately? And ultimately, that's not just to protect the patient, that's also to protect you as a professional, to make sure that you're safe in your practice, that you adhere to your local policy or employer rules and regulations, and ultimately to make sure that your patient's data is safe and secure. And just to finish, there is a whole host of resources which I've referred to throughout the course of this presentation on screen here. If you are in doubt about anything in terms of obtaining valid consent, particularly during video consultations, then I would encourage you to spend some time reading some of these resources. They are very helpful, and I'm sure will answer your queries. But just in summary, thank you very much for having me today. It's been a pleasure to talk to you about consent in the digital age.
Goodness me, what an interesting case study, highlighting the importance of information giving to patients, as well as the absolute necessity to document all aspects of care so accurately in patient notes. As stoma care nurses, we are often the ones to offer further explanations on operative procedures once the patient has seen the consultant. Being that strong patient advocate is fundamental to ensure that they have the appropriate information to enable them to make the correct decisions. Thank you for watching this episode. I do hope you've enjoyed it. This episode can be viewed on demand at Salt's Healthcare website, so it can be stopped and replayed at your convenience, giving you time to write notes or reflect on certain aspects of the session if required. If anyone has any follow-up questions, then please do email us at discover@salts.co.uk. Please do click on the link at the end of this episode or from the main Discover Series webpage to access the evaluation form. Once you have completed this form, you'll be redirected to a page enabling you to print out your own certificate of attendance. The next session in the Discover Series will be launched on Thursday, the 25th of November. In this third and final episode of Discover Series 3, we will hear from both Barbara Milleray and Michelle Scripps, who share with us their experiences of setting up and running virtual consultations for preoperative stoma assessment.